I'd like to welcome you to our presentation on estate planning and trust. My name is Rob Zapolis. I'm an attorney. I've been practicing law for over 33 years. I know I don't look that old, but I'm actually quite old. My concentration in the practice for about the last 25 years has been estate planning and estate administration. And over that 25 and 30 years of being in that area of the law, we've learned a lot about what works and what doesn't work. So tonight I'd like to share some of those things that we've found work and don't work, so that you'll have a better idea of what kind of planning you might do in the future and what kinds of things are available to you. So the first thing we like to do is share information about what works and what doesn't work, what kind of planning is good, what kind of planning is beneficial. And the second thing I like to do is motivate you. A lot of people listen, read, learn a lot about estate planning, but never ever take the step to do something. They're always going to do it next year or next month. And that's one of the biggest problems we find in estate planning, is that many people wait too long. They just wait till it's too late or till they don't have a chance to really do what they should have done, maybe when they're a little younger or when they were more able to do something they had on the front of their burner, the front burner of the stove, and they were thinking about doing it and they just didn't do it. So I'd like to motivate you to do something, and I'd like to also share with you this information. Now, when I talk about estate planning, there's two big misconceptions about estate planning I'd like to dispel right off the bat. First of all, a lot of people have heard that you have to be rich to do estate planning. If you're not rich, you don't need to do estate planning. If I'm not a rich person, if I'm not wealthy, if I don't have more than $1 million or $2 million, I don't have to plan. That's just not true. Planning your estate is about control of what you own. It's not about how wealthy you are. It's not about how much money you have. It's control of what you own throughout your life, maybe even after your death. So control is very important, and it doesn't matter how much you have. So don't listen to anybody that tells you if you're not wealthy, you don't have to plan. The second misconception is that estate planning is only for old people, that you have to be old, like after you retire, someday when you're old, you should do your plan. And the problem with that thinking is it misses a whole section of our life when we have children, we have young children, we have families, grandchildren. There's a lot of things that are going on in life that if we had a disability or if we died prematurely, if we're waiting to do our plan till we're old and retired and things are settling down, it might not get done in time. So one of the first things that I counsel people on when we meet them is it's not age and it's not wealth. It's at the time in life when you feel comfortable that you want to plan your estate, that's when you want to do it. You don't want to think, well, I've got to do something, but I'm going to do it next year or next month or in the future. Once you realize this is something I should do, you do it right now. That's really important. When I talk about estate planning, I could bring out a bunch of legal books and we could read cases and we could talk about all the statutes and the IRS code sections, and we could do a lot of legal learning that would be, first of all, very boring, and it would take a long time. We're not going to do that in this presentation. What I'm going to do is simply tell you a story. I'm going to tell you a story about two people and their family and how these people planned their estate. Some of the choices they made you're going to see were wrong, and some you'll see were right. And I hope that you can then compare this family and their situation to your own. You could say, well, I can see how this would work for me and my family, not based on knowing a lot of laws, but just how things work. What's the bottom line? How does this stuff work? So we're going to tell a story about two people in their family. We're going to call them Bill and Mary. Now, Bill and Mary are people just like you and I. They're not wealthy. They're not rich. They're comfortable. They have a house. They have some stock. They have some assets that they purchased over the years, some CDs. Bill has a 401k plan at work. Mary has an IRA. But they're not wealthy people, but they're very comfortable. They've worked very hard for what they have in their life. When they bought these various assets over the years, in most cases, they put these assets and these different investments into a form of ownership called joint tenancy. Pretty much everyone here, how many here have heard of joint tenancy? Anybody? Joint tenancy is a form of ownership, and there are 4 forms of ownership. So when you buy something, you have to choose a form of ownership. We'll go through those forms of ownership really quickly. The first form of ownership is called sole ownership. That's if you buy something all by yourself. So if you want to open a bank account and your name will be the only name on the account, or you want to buy some real estate and your name will be the only name on the deed, you'll be the only owner of that asset, that's the first form of ownership. It's called sole ownership. The second form of ownership is called tenants in common. Tenants in common are like partners. So if you buy something with another person and you say, well, we're going to be like partners. We want to each own our own share, and it can be unequal. You could own 1/3 and your partner could own 2/3. And if one of those partners, while they own that property, were to die, their share goes through their estate, so it would go through their will or to their heirs. Joint tenancy, which is used by most married people to hold most of their assets, is similar to tenants in common in that you have to have 2 or more owners. But there's a big difference. 2 big differences, actually. The first big difference is that, remember when with tenants in common, you could be unequal. I said you could be 2/3 and someone else could be 1/3. Well, with joint tenancy, you can't be unequal. They must be equal owners. And that's really important to understand that, because you'll see later how that impacts Bill and Mary's planning. Second big difference. Remember I said with tenants in common, if someone dies while they own an asset partially as a tenant in common with someone else, their share goes through their estate. So it would go to their children or through their will or to their heirs. With joint tenancy, that's not true. If a joint tenant dies, their share goes instantly by operation of law to the surviving joint tenant. It's called the right of survivorship. Now, some people look at that as an advantage, and you'll see that it can be an advantage, but it also can be very dangerous. It can be a very difficult thing when you don't have the proper joint tenants on an asset and somebody dies. You can actually disinherit people. You can actually have people get assets that that you don't intend them to have, and we'll talk about that in a few minutes with the story. And then the fourth form of ownership is called trust. So we have 4 forms of ownership: sole ownership, tenants in common, joint tenancy, and trust. Now, most married people own everything as joint tenants, just because when they bought things over the years and they went to the bank to open an account and they bought their first house, they got these assets and they were just told that joint tenancy is how most married people hold their assets. It's the best form of ownership, and that's what they did. Bill and Mary have almost everything in joint tenancy. There's the average married couple. Their house, their savings account, their CDs, their stocks are all held in joint tenancy. But if you ask Bill and Mary, are you upset about that? Are you mad about this joint tenancy thing that people have put on you over the years? They said, no, we like joint tenancy. We think it's great. Bill says, if I die, instantly my wife owns everything. There's no court. There's no probate court. There's no time delay. She instantly owns everything. And if she dies, instantly I own everything. So what's the problem? That's the way we want to own things. It makes sense for us. And everything's going along smooth, and they feel pretty confident in their plan, except something bad happens. Bill has a stroke. He's taken to the hospital. He's in intensive care. He can't talk, can't sign his name, can't get out of bed. He's really sick. Now, who's going to manage Bill and Mary's assets for them while Bill's laying in the hospital sick? He can't sign, he can't make decisions. Who's going to manage his assets? Well, you're probably thinking, well, Mary. You didn't say anything was wrong with her. She's healthy, right? If you said Mary will be able to manage things, you're partially correct. She will be able to manage certain things. For example, does Mary need Bill to sign a check on their joint checking account? No. She can sign checks. She can take money out of savings. So most of their bank accounts, there's no problem. Either joint tenant can withdraw money, can transact business on a joint checking account. But almost all of Bill and Mary's other assets are now frozen and unavailable to Mary because of her husband's illness. You might be thinking, well, what? What are you talking about? Well, let's just look at their house. They have a home. They bought it as joint tenants. Bill's sick. He can't sign his name. He can't talk. He can't make decisions. Can Mary sell that house, get a mortgage or a home equity loan without her husband's signature? And if you're thinking no, you're right. And if you don't believe me, try it. Go to the bank and say, I want to borrow some money against my house, but don't tell my spouse. It's a secret. I just need the money for something I want to do. And you know what's going to happen? They're going to tell you we can't do that. If we're going to put a mortgage on a house, both owners, who are joint tenants, equal owners, they own an undivided equal percentage, have to sign on the mortgage or the note. Or to sell the property, the same thing. So now Mary realizes that their house is frozen. It's unavailable. She can't sell it. She can't get a home equity loan. She can't get a mortgage. What else would be frozen? Let's take a look at, for example, they bought some stock over the years. They have some stock in IBM, AT&T, Enron. Well, forget about the Enron, but the AT&T and the IBM. Can Mary go to the stockbroker with a certificate out of the safe deposit box and say, I want to sign this over because my husband's sick, I got to raise money, I want to sell this stock? Will they sell it? Well, what the broker will tell her is, your husband and you both have to sign the stock certificate or the stock power. The signature on the stock has to be signature guaranteed with a medallion stamp. Now, if you don't know what that is, it's basically like a super notary. It's a notary that only banks, commercial banks, and stockbrokers can give. So not only does Mary have to get Bill to sign it, which she can't, but she also has to get a medallion stamp. So all the stock certificates are unavailable to Mary. What about Bill's 401k plan at work, his pension plan? Can Mary take any money out? The answer is no. Again, if you don't believe me, try it. Go to your spouse's work and say, I need to get some money out of my husband's 401k plan. I got some shopping to do. You know what they're going to tell you? You can't do it. He could take money out. That's up to him. But while he's alive, you can't take any money out. And the fact that he's disabled doesn't change that. The fact that he's unable to sign is the same as if he didn't want to sign. He's not able to sign. The other spouse has no control over that asset. So really, if you look at it, some of the biggest assets that Bill and Mary have, their home, their retirement, their stocks, their investment accounts, are frozen. Now, what's Mary supposed to do? She can't live like that. She's got to do something. So what she's going to have to do is hire a lawyer and go to court and file what we call a guardianship proceeding or a conservatorship. In some states, it's a conservatorship. In Illinois, we call it a guardianship. So what Mary has to do is go to court and say, my husband's sick, he can't sign, he can't transact business, I need to get control, and I want to be appointed as his court-appointed guardian. The court then can look at the situation, take jurisdiction over the estate, and appoint Mary as her husband's court-appointed guardian. What's the problem with that? Why would that be a problem for Mary? Well, first of all, she's got to hire a lawyer, she's got to go to court, she's got to post a bond, and all that means she'll be spending money. She's a large expense item to go and become someone's guardian. If you go to court to become a guardian, you've got legal fees, bond premiums, filing fees, accounting fees, and those happen every year. They don't think about the disability. It's overlooked by many people in their planning. They just completely overlook it, and it's very important. Many, many people, 1 out of 2, I believe is the statistic, will become disabled sometime during their life. So 1 out of 2 people at some point in their life will need some type of long-term care disability, and if you're not prepared for it, the court can be involved in your estate, and it's a very large expense item, very difficult for the family. What happens if Bill lives for a while, never really gets better, and he dies? Where's everything go? To Mary. She's a joint tenant. Does she have to go to court or anything? No. The second Bill dies, Mary either is a beneficiary or an owner of everything. So the house, the stocks, the bank accounts are all Mary's. What form of ownership is she in now? Sole. She was number 3, joint. Now she's number 1, sole. She's the sole owner of everything. Mary doesn't like that. She's thinking to herself, what happens if I die? What's going to happen here? I mean, I don't have anybody, I don't have any plan. So she's upset, and she's talking to some people, and what they tell her to do, her friends and neighbors, they say, look, put your daughter, Susan, on all the assets with you as a joint tenant. That way, when you die, instantly, Susan will own everything. There'll be no court or anything, no probate court, and Susan will own the whole estate instantly, and it solves your problem, just like when Bill died. She says, yeah, you know, when Bill was sick, it didn't work very well, but when he died, I didn't have to do anything. I didn't have to pay a lawyer or go to court or anything, so, okay, that's what I'll do. So she adds her daughter Susan on all the assets, her house, stocks, bonds, bank accounts, everything. Daughter Susan is now a joint tenant with right of survivorship. Mary feels comfortable now. She's got a plan. Let me tell you just a little bit about their family, though. I didn't give you a lot of background. First of all, they have 2 children, son John, daughter Susan. Son John's had a very difficult time in life so far. He's been in college now about 12 years. His probation officer believes he'll be out of college soon. He just needs to pick a major and study harder. He lives in a van behind Mary's house, but he visits his mom every single day of the year. Happens to be dinner time, but I'm sure that's just a coincidence. Susan, on the other hand, you would probably consider to be like the model daughter. She's honest, smart, has a career of her own, wonderful person. That's why the neighbors and the friends said, just put your daughter on everything. When you die, she'll inherit everything, right of survivorship, no court or anything. She can take care of your son, John, keep him off the streets, give him a little spending money. She can watch him because you can't give him all the money. She goes, you're right, I can't trust John, so I'll put Susan on everything. And she trusts her daughter 100%, and she has no reason not to. So Susan now a joint owner, joint tenant with her mother, Mary, on everything, and Mary thinks she's got it solved. What happens if Susan, one day, going over to visit Mom, driving in the car, fooling around with the radio, trying to get a good station, misses a stop sign, drives right out into the intersection, doesn't even slow down, causes a very serious automobile accident in which people are severely injured. Now, all those people that are severely injured file lawsuits against Susan, don't they? Because she is the cause of the accident. She wasn't looking. She wasn't paying attention. She didn't mean to do it, but she was the cause. She has insurance, though. She's not, she's smart. She's got insurance. She has good insurance, $100,000, $300,000 coverage, which means the insurance company will pay up to $300,000 in damages to those people that were injured. Unfortunately, when all those lawsuits are over, there's a $2 million judgment against Susan. Now, she's only $1.7 million short. What's she going to do about that? Well, she's going to have to file for bankruptcy because she doesn't have $1.7 million. She's got the $300,000 from the insurance company. When she files for bankruptcy, the bankruptcy court's going to say, oh, yeah, we'll discharge you. You won't have to pay that debt, but we do need to see a list of any assets you own or any assets on which you have any ownership interest. Remember, joint tenants must be equal owners. Remember we said that you can't be unequal. That means when Mary put her daughter on her house, how much of her daughter's house does Susan now own? Half, 50%. Same thing with the stocks, same thing with the bonds, same thing with the investments. Half of everything that used to be Mary's is now, by definition, because they're joint tenants, owned by Susan and is subject to the claims of her creditors. Now, will the creditors get all that? They may try. Mary now, though, will be in court fighting over her own assets in her daughter's automobile accident or bankruptcy case. Because they could say, well, you own half of a house, you have half of some stock, and we're going to use those to pay off all those people you injured. So Mary could be in court fighting for her own home, her own stock, her own investments, to try to establish that there was a convenience account, there's a bunch of things you can try to do to protect it, but it's also very difficult to do that. So Mary would be in a position where she have to hire a lawyer and try to make sure she didn't lose these assets. It's a very dangerous place to be when someone else owns half of what you own. And it doesn't have to be an automobile accident. It could be anything. It could be a divorce. It could be any kind of a lawsuit. One of Susan's children could get sick and rack up a bunch of medical bills and cap out the medical insurance. All of a sudden, Susan's getting bills from the hospital for $20,000, $30,000, $40,000. She can't pay those. She may have to go bankrupt again. What are we dealing with? Half of everything that used to be Mary's is potentially now Susan's. Very dangerous place to be, adding people onto your accounts. You're making them a current owner equal to your own ownership. So if you put someone on a house with you, you own half now and they own half. And a lot of people don't know that. They don't know that they're giving away a present ownership interest when you make someone a joint tenant with you. It's very dangerous planning. What happens if Mary doesn't do that? Let's say she just leaves everything in her name alone. She just said, I'm not going to put anybody else on it. I heard bad things. Well, what happens if she leaves everything in her name as a sole owner and she gets sick? What happens if Mary later in life gets Alzheimer's disease? Then she doesn't really know what's going on. She doesn't know what day it is. She can't sign her name anymore. Somebody's going to have to manage for Mary now. Somebody's going to have to go to court and become her guardian, just like she did for Bill when he was sick, right? What do you think about John becoming Mary's guardian? What do you think? Maybe Susan would be better. What about the public guardian? Here's the bad part. If you don't have a good estate plan, if you don't have an estate plan that works, you have no idea who your guardian is going to be. There is no legal document you can prepare in advance to appoint your own guardian. So the court will appoint a guardian for Mary when she's sick and needs a guardian, and the court could appoint her son John, her daughter Susan, the public guardian, or somebody else. And so she's lost control of the estate to the court system. She no longer controls her estate. The guardianship court will take over. They will appoint a guardian for her, and the guardian will handle her estate. What happens when Mary dies? Upon Mary's death, all the assets she owns are in her name alone because she didn't put anybody else on there. Those assets then have to be transferred to her heirs or through her will. A lot of people have heard and believe that if you have a will, you avoid probate. They were told someday that if somebody told them, if I do a will, I'm set because now once I have my will set up, everything goes to my spouse, and if they die to my children, we avoid the court system. The problem with that is they don't understand what a will is. Once you understand what a will is, you'll realize that it's impossible to avoid probate with a will. A will is a set of written instructions to the probate court that tells the probate court what to do with your assets when you die. It has to be filed with the clerk of the probate court, And if you're going to administer the will, it has to be done through the probate court. So by doing a will, you really don't avoid the court system. You kind of guarantee that you're going to end up in the court system. What if Mary has no will? Well, she still has to go to court. Well, she doesn't. Her estate does, her children. So John and Susan now, after Mom dies, have a house, stocks, bonds, bank accounts, all in Mom's name. And whether or not they have a will, if they have a will, they would be called legatees. They're the beneficiaries of the will. If there is no will, then they're the heirs. So they would get the assets. It's not, a lot of people think if you go to probate, like the state takes all your money. That's not what's going to happen. But what's going to happen is they have to have a procedure through the court system to administer that estate. There's a 6-month claims period that for 6 months you can't close the estate, so the minimum it will be open is 6 months. Usually estates are open for a year, year and a half in a probate court. And there's expenses. I mean, you have to pay a lawyer, you have filing fees, you have accounting fees. So all these expenses pile up against the estate. And you really have no control over that. Like if I asked you, and anyone in this room, if you died tomorrow and your estate went to probate, how much would it cost? You'll probably say, well, I don't really know. I never thought about it. And the bad part is, neither do I. I have no idea how much your probate's going to cost. That's one of the problems with probate. I've seen probates that were very inexpensive, very reasonable. I've seen other probates that were very expensive because you're going through the court system. And there's things that have to be done, there's procedures that have to be followed, and of course the lawyers are involved, there's accountants, maybe there's 2 or 3 lawyers involved if there's any disputes in the family, and things can get expensive and get out of hand. So what's the answer? What would be an answer? Well, we talked about the first 3 forms of ownership, sole ownership, joint tenancy, a little bit about tenants in common. What was the 4th form of ownership? It's called trust. It's a way to own things. But what is a trust? Well, a trust is basically a legal document prepared by a lawyer that lists all of your instructions. What kind of instructions? Well, let's start with the first instruction. While I'm alive and well, I want to be in charge of everything. I want to be able to buy, sell, spend, save, do whatever I want with my assets. I don't want anybody telling me what to do. I don't want to have to pay any annual fees. I just want to be in charge of my stuff. But if I ever get sick and I'm in the hospital and I can't sign, I can't make decisions, I do not want a court-appointed guardian. I actually want to appoint somebody. And you can do that in the trust. You can say as one of your instructions, if I'm ever disabled and I can't make decisions, this person or these people will be in charge of my estate. They don't have to go to court. They don't have to hire a lawyer. They don't have to pay any legal fees because they would just be appointed by you in the document. And you can do an order of succession. You can have multiple people. First my daughter, then my son, then my cousin, whoever you want, or you can also use a bank trust department. Third instruction might be, and when I die, I don't really want my estate to have to go to court. I don't really want to wait 6 months to a year. I don't want to have my children going through the court system. I simply want the people that I want to get my estate, whether it be my spouse or my children or my grandchildren, to just receive the assets without the necessity to go through the court system and pay fees and costs and filing fees and accounting costs and lawyers' fees. I just don't need that. I don't think we need that in our family. We can just distribute it through this instrument that or this contract, this document we call a trust. So a trust is a legal document, but I'd like you to forget about that. Never ever think about a trust as a legal document again. Whenever you think about a trust, think about a box. So when you sign your trust at the lawyer's office, think that you just created this big box, like a safe deposit box. When you rent the safe deposit box at the bank and you go down there for the very first time, what's in it? Nothing. It's empty. What if you left it that way? Kind of a waste of money, isn't it? Why would you rent the safe deposit box at the bank and never put anything in it? It'd be kind of a waste. Same thing with a trust. If you create a living trust at the lawyer's office and you sign it, and you have this trust with all these instructions, and you leave everything in the first 3 forms of ownership, it doesn't work. Waste of your money. So what do? Well, after the lawyer forms the trust and you sign it, and you got this legal document with all these instructions, and you've created this big legal box, you got to put everything in the box. How do we do it? Just simply retitling everything from the first 3 forms of ownership into the 4th. So the lawyer will prepare a deed for Bill and Mary. The deed will say, we, Bill and Mary, as joint tenants, convey this house to us, Bill and Mary, as trustees of our trust. So the deed will say, Bill and Mary, trustees of the Bill and Mary Living Trust. The house now is in the 4th form of ownership, and they'll do that with every other asset they own. Their bank accounts will say Bill and Mary trustees of the Bill and Mary Living Trust. Their stocks, their bonds, their mutual funds will all say Bill and Mary trustees of the Bill and Mary Living Trust. Now if Bill has a stroke, taken to the hospital, can't sign his name, can't talk, can't make decisions, does Mary have to hire a lawyer, go to court, pay legal fees, post a bond, make a public record? No, because the trust says if I, Bill, ever get sick, my wife's in charge of everything. I give her authority through this contract, through this legal document. She's in charge of the box. She can do anything. Doesn't need to go to court. I don't have to worry that someone else will be appointed. She will be my trustee. And if she can't do it, I'll have somebody else. What happens when Bill dies? Well, just like the first example, Mary's the owner. Mary's now is the trustee of the Bill and Mary Trust. She can live off the assets, live the rest of her life, enjoy the benefit of them. Does she have to worry if her daughter or son gets sued? No, because they're not on the assets as owners. She's the owner. What happens when Mary dies? What happens when Mary gets sick in the future? Let's say she does get Alzheimer's disease. She can't remember things. She can't sign. Does she have to worry her son John's going to be appointed as her guardian? No, because she's not going to have a guardian. The trust says if I, Mary, ever get sick and my husband already died, I appoint my daughter Susan. And if Susan can't do it, I appoint my brother Mike. I want to be in control. I don't want the court appointing a guardian for me. I want to appoint trustees for me under my direction. I want to keep control of what I own. And upon her death, is there going to be any probate? You probably guessed already, you probably know the answer. The answer is no. Because all the assets have already been retitled during their life into the name of the trust. Why do we go to probate? Well, remember we had a house that was in Bill and Mary's name and they died. We have to retitle that house into the children's name. It has to go to court. In this case, we've already done that. So while they're alive, they put all the assets into the box. When Bill died, the box went to Mary. Mary died, the box goes to John and Susan. There's no probate court, there's no expense, there's no time delay. It's all handled by the trust, by the fact that they've done their homework. Fourth form of ownership, trust. It's a lot easier than people think to do a trust. A lot of people think, oh, this is going to be complicated. I have to pay annual fees, and maybe some bank takes over my stuff, and I have to report back to the lawyer every year. None of that is true. In a living trust, you are the trustee. Your children or your siblings or whoever you want can be the backup trustees. There's no annual fees. There's no maintenance fees. Once you set the trust up, as you buy and sell things, you just put them into the fourth form of ownership. It's that simple. So, in a nutshell, to summarize, the bottom line is by doing a trust and using the fourth form of ownership, that fourth form of ownership allows you to keep control. Remember at the beginning of the presentation I said control is really what we're talking about. You don't have to be rich. You have to control whatever it is you own. And trusts allow you to do that. They allow you to keep control throughout your life, even if you become mentally disabled, and even after your death, you remain in control. No court system, no legal fees, no time delay based on the probate system or the guardianship system. You've got it all set up ahead of time. You're keeping control of what you own throughout your life. And trusts are a lot easier to do than people think. Thanks for your attention.